Welcome to A Will is Not the Only Way. I'm T.L. Brown, a Senior Fiduciary Officer with Members Trust Company. This webinar is part one of a series where we will discuss various concepts involving estate planning. Today, we will focus on revocable living trusts. I want to immediately start out with the statement that trusts are not just for millionaires, but rather many of us can benefit from having a trust. We will review the basics of a revocable living trust, who should have a trust, considerations when funding your trust, choosing your trustee, and finally, we will discuss ways to assist your trustee. Please feel free to post any questions in the chat box as we will have Q&A at the end. By way of background, Members Trust Company is a nationally chartered trust company owned by our credit union partners. We're unique in that we bring together credit union DNA, Wall Street experience, and legal backgrounds for the benefit of our clients. Our client-first approach means that we seek to educate and empower our members. For example, with webinars such as this, while also being easily accessible to our clients and providing innovative financial products and solutions. Now let's move to our discussion. When you think about planning for future circumstances in life or upon your death, there are four foundational documents that give expression to how you would want your affairs handled. These documents are a revocable living trust, last will and testament, advanced healthcare directives, and a financial power of attorney. We will discuss wills more in depth on a future webinar, but I want to briefly mention both a will and testamentary trust so that we can distinguish these from a revocable living trust. A will is the most basic part of an estate plan, which everyone should have. It's a document that disposes of your property upon your death. In order for your will to have effect, it has to be brought before a court of law after you pass away and approved as part of a process called probate. Some people may have a will that calls for the creation of a trust after the estate is settled. This type of trust is called a testamentary trust. So with a will and a trust that's created under your will, remember two things. One, they don't get triggered until after your death. And two, they require court involvement. What is a revocable living trust? This is a trust that is established during your lifetime pursuant to a trust agreement. The trust agreement contains your wishes for how you would want the trust assets to be handled, both during your lifetime, upon your incapacity, and upon your death. Once you properly execute the trust, it takes effect immediately. Yet, because it's quote unquote revocable, you can change it at any time while you are alive, so long as you or an authorized representative have the capacity to do so. In order to create the trust, you should hire an estate planning attorney to draft a trust agreement. Then you retitle assets into the name of the trust such that the trust becomes the legal owner of those assets. And those assets would now be administered as part of the trust agreement. You would have complete and unfettered control over the trust as if you had kept those assets in your individual name without any court oversight. For tax purposes, any income earned by the trust would still be reported under your Social Security number. Note that a revocable living trust is also private and not subject to public record as a last will and testament might be. Now, I want to draw your attention to the bottom of this slide. Incapacity planning is one of the most important advantages of having a revocable living trust. If for some reason you become incapacitated, your trust can continue to pay your bills and meet your support needs without someone necessarily having to go to court to become your guardian. How does this look in practice? The person creating the trust is called the grantor. Usually the grantor will also serve as trustee during life while healthy and while able to handle his or her own financial affairs. If and once the grantor becomes incapacitated, the trust agreement will appoint a new trustee to step in. The new trustee assumes control of the trust assets and continues with paying the grantor's taxes, medical bills, and monthly bills while the grantor is still alive. I want to point out that a financial power of attorney, if properly drafted, could achieve a similar result. However, one major difference between having a financial power of attorney and a trust is that the financial power of attorney ends at death, whereas your revocable living trust remains effective upon your death. So a revocable living trust provides continuity with taking care of your affairs at incapacity and after your death. Upon your passing, the trustee collects any additional assets that are due to the trust as a result of your death, such as life insurance or retirement benefits if you named the trust as beneficiary. The trustee then settles your final affairs and distributes the remaining assets to the beneficiaries in accordance with the terms of the trust agreement, again, without any court involvement. Who needs a revocable living trust? At Members Trust Company, we like to ask who doesn't need a revocable living trust. We've already discussed the benefits for those of you who want to plan for both incapacity and death. So let's examine some other scenarios where it makes sense to have a trust. First, is anyone looking to preserve family harmony after you pass away, especially if there are multiple loved ones involved? Second, is anyone who has a loved one with special needs. If you want to provide for someone who is on certain means-tested government benefits, then if you leave money to them outright, you could disqualify them from receiving those government benefits. If instead you have a properly drafted revocable trust, which upon your death calls for the creation of a special needs trust to supplement but not replace those government benefits, then not only would you be able to preserve your loved one's benefits, but also potentially add to their quality of life. Next is someone with a blended family. Within your trust, you could ensure that both your children and your spouse are provided for. Another situation is where you have a loved one who is not experienced with money and you're concerned that they could either squander their inheritance or be taken advantage of. Within your trust agreement, you could leave provisions that restrict their access to trust money. We also recommend a trust for clients who either don't have kids or your loved ones live too far away to ensure that your affairs are handled. Moreover, revocable trusts are useful for individuals with large estates in need of tax planning. Though if someone's estate exceeds the current federal estate tax exemption, which is just over 12 million, some additional planning techniques would be beneficial. If you decide to create a revocable trust, then you also need to put assets into the trust in order to achieve your purpose. If you're more concerned about having things taken care of if you become incapacitated, you should look at retitling assets into the name of your trust sooner rather than later. That would also make it easier for your trustee upon your passing because the assets would already be part of the trust. The decision of what to put into your trust should be based on your individual circumstances. However, on behalf of all trustees, I will tell you that the most important thing we need is money or access to money to support the costs of the trust. If, for example, real estate is placed in the trustee would be responsible for insurance, taxes, and upkeep. Think about how easy or difficult it would be for the trustee to administer the proposed assets. For example, with personal property, where would the personal property be stored? How easy would it be for the trustee to collect and insure it? With business interests, would a trustee be expected to manage the business for any period of time? If so, what expertise is needed to do so? How easy will it be to value and eventually dispose of the interest, whether by sale or otherwise? Certain types of assets require a trustee with specialized knowledge and/or resources. Which leads us to a discussion about selecting your trustee. Let's look at some considerations. And as a reminder, please feel free to post your questions in the chat box. You can choose either an individual or professional, or you could choose both and name them as co-trustees of your trust. Not only should you do your due diligence with respect to your trustee, but you want to give the same consideration to choosing all members of what I call the care team for your estate planning documents. Your trustee, executor, your healthcare agent, and your financial agent. Here are some considerations when choosing your trustee and members of your care team. I won't go through all of these items as most are self-explanatory, but you'll certainly want someone that's reliable, responsive, organized, and has a great attention to detail when it comes to handling all of your affairs. How can members' trust help you? On this screen, you see a number of roles in which we are able to serve. And I'm just going to highlight two items for today: trustee and agent for trustee. If you decide to name us as trustee, then we can step in once you pass away or become incapacitated, and we will administer your trust. Alternatively, if you decide to create a trust, but you decide to name either yourself or another individual as trustee, then the trustee could separately open an investment management account with us, and we will be what's called agent for trustee. That would allow for an easy transition if we were to become trustee in the future, since we would already have the account here at Members Trust. Here's a sampling of some of the things that we do as trustee, including collecting and appraising assets. We can secure and sell your property, file taxes, notify creditors. Upon your passing, provide account statements to your beneficiaries and communicate with them. And most importantly, we distribute the assets to them in accordance with your trust agreement. I want to finish by discussing ways in which you can make your trustee's job much easier. First, provide the trustee with a list of everything important that's related to the trust. For example, the location of your important documents, your financial account information, the contact information for your beneficiaries, attorney, and accountant. Also, there will usually be one family member who's sort of the go-to person. Be sure to share that information with the trustee and vice versa. Also, it's helpful when you can simplify and consolidate your assets into as few accounts as possible. Once a third party steps in as trustee, they have to take custody of the trust assets. But when you have accounts at various institutions, the trustee has to work through a lot more red tape and the procedures at each of those institutions in order to get control of the assets. Next, if you can retitle assets and or your safe deposit box into the trust while you are alive, it enables the trustee to have quick access to necessary funds or paperwork when the time comes. If you intend for the trust to be the beneficiary of your life insurance policy or any retirement assets, don't delay updating your beneficiary designation. You should also provide a copy to your nominated trustee. Otherwise, the company holding the account would only share information with the listed beneficiary on file. I want to mention a couple of ways where you can help your trustee manage the relationship with your beneficiaries after your passing. First, to the extent that you leave personal property, such as household effects and jewelry in the trust, please leave clear instructions as to how those items are to be distributed. In my experience, the selection and disposition of the personal property by far brings the most arguments and complaining amongst the beneficiaries. Second, while you are under no obligation to share the provisions of your trust with your beneficiaries, it does make things smoother for the trustee if you decide to do so. Alternatively, it's helpful when you can at least communicate to your beneficiaries that you have a private trust in place and a trustee to carry out your stated wishes. Finally, consult with your nominated trustee before you finalize the trust agreement. See what requirements they may have in order to accept the role and share a draft of the agreement with them. If you decide to nominate Members Trust Company as your trustee, my colleagues and I have looked at hundreds, probably thousands of trust documents over our careers, and it would be our pleasure to work with you and your attorney as you are putting your trust and overall estate plan into place. Here are a list of contacts should you have any questions on trusts or any matter as pertains to your estate plan.